In 2008, Abigail Fisher, a young woman from Sugar Land, Texas, was denied admission to the University of Texas at Austin. This rejection, seemingly routine, sparked a legal odyssey that would culminate in two landmark Supreme Court decisions and fundamentally redefine affirmative action in higher education. Her case, Fisher v. University of Texas, began as a challenge to a single university's admissions policy, but evolved into a constitutional question with nationwide implications for every college applicant. How did one student's personal disappointment trigger such a seismic shift in American law? And stick with me, because the final ruling in this case isn't just about who gets into college. It's about how the Supreme Court began to narrow the very definition of diversity, and that nuance is what reshaped admissions for a generation of students. Abigail Fisher's rejection from the University of Texas at Austin in 2008 didn't just mark the end of one college application process. It sparked a decade-long legal battle that fundamentally reshaped affirmative action in higher education. Her case, Fisher v. University of Texas, ultimately landed before the U.S. Supreme Court twice, leading to landmark decisions that continue to influence how universities consider race in admissions even today. Before Fisher, many understood the Supreme Court's Grutter v. Bollinger ruling to permit a critical mass justification for racial diversity. However, the Fisher litigation forced a much stricter interpretation, demanding that universities prove there are no workable race-neutral alternatives to achieve their diversity goals. This case didn't just impact a single student. It challenged the very legal framework of affirmative action, prompting institutions across the country to reevaluate their admissions policies. So, how did one student's denied application lead to such a profound legal shift? Our story begins in the fall of 2008, when Ms. Fisher submitted her application to the University of Texas at Austin. At the heart of Fisher's challenge was a seemingly objective process that held a secret, one numerical index hidden from applicants, where race was a considered factor. Abigail Fisher, a white student, applied to UT Austin in 2008. She was not in the top 10% of her high school class, meaning she did not automatically qualify for admission under Texas's top 10% law. This state law guaranteed admission to UT Austin for Texas high school graduates in the top 10% of their class. For the remaining 25% of the incoming class, like Fisher, UT Austin employed a holistic review process. This review considered various elements, including essays, extracurricular activities, and two internal scores: a personal achievement index, PAI, and an academic index, AI. Crucially, race and ethnicity were considered as a factor of a factor within the PAI. This meant it wasn't a direct point addition based on race, but rather one element among many contributing to the holistic assessment of an applicant's background and experiences. Fisher's academic record included a 3.59 GPA and an 1180 SAT score. Despite these qualifications, she was ultimately denied admission. The university maintained that her denial was not due to her race, but rather a reflection of her overall standing in a highly competitive applicant pool under the holistic review. Rejected. But was race really the problem? But was race truly the deciding factor in Abigail Fisher's rejection, or a convenient narrative? Fisher's core argument was that the University of Texas denied her admission based on her race, thereby violating the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act of 1964. She claimed that UT's use of race as a factor in its holistic review process amounted to reverse discrimination, asserting she was more qualified than some minority students who gained admission. At the time, the legal precedent was Grutter v. Bollinger, a 2003 Supreme Court decision that permitted race as one factor in a holistic admissions process to achieve student body diversity, while simultaneously prohibiting quotas. Both the U.S. District Court for the Western District of Texas and the U.S. Court of Appeals for the Fifth Circuit initially ruled in favor of UT, upholding its admissions policy as narrowly tailored to achieve a compelling government interest. However, in 2013, the case, now known as Fisher I, reached the Supreme Court. The court remanded the case back to the Fifth Circuit, demanding a strict scrutiny review. This meant the lower courts had to ensure UT's policy was not just permissible under Grutter, but truly necessary, and that no race-neutral alternatives could achieve the same diversity benefits. The common narrative, heavily amplified by Fisher's legal team, was that she was more qualified than some admitted minority students, fueling the reverse discrimination claim. This set the stage for a critical re-examination of UT's entire admissions framework, raising the stakes dramatically for the future of affirmative action. The question remained, could UT truly demonstrate that its race-conscious policy was the only path to a diverse student body, or would the Supreme Court ultimately find it unlawful? Despite powerful legal challenges, the Supreme Court, in a 4-3 decision in 2016, Fisher II, upheld the University of Texas's admissions policy. Justice Anthony Kennedy, writing for the majority, found UT's program narrowly tailored to a compelling state interest in diversity, concluding that no workable race-neutral alternatives existed to achieve the same level of diversity. The court significantly deferred to UT's educational judgment on the importance of a diverse student body. Justices Samuel Alito and Clarence Thomas penned strong dissents, arguing UT failed to meet the rigorous strict scrutiny standard for racial classifications. Justice Thomas reiterated his view that such classifications are inherently suspect and impermissible. Nevertheless, Fisher II largely preserved the Grutter v. Bollinger precedent, 2003, affirming race could still be one factor among many in college admissions, provided it was narrowly tailored and subjected to strict scrutiny. This outcome meant race-conscious admissions practices had survived a significant legal challenge for the time being. Yet, the question lingered. What if race hadn't been a factor at all in Abigail Fisher's application? But what if the entire premise of Fisher's challenge, that race was the determining factor, was fundamentally flawed? Post-verdict analysis began to reveal a critical detail. Abigail Fisher's application was not competitive even if race had been entirely removed from UT's holistic review process. According to university records, Fisher's Personal Achievement Index, or PAI score, was 2.76. For context, the average PAI for admitted students not in the top 10% was 4.25. This significant discrepancy suggested her academic and extracurricular qualifications simply did not meet the rigorous standards for the limited holistic review spots. Indeed, data presented in court indicated that 42 white students with lower academic index scores than Fisher and 168 white students with lower PAI scores were admitted through holistic review. This demonstrated that a complex array of non-racial factors, such as essays, leadership qualities, and unique talents, were heavily weighed. Legal scholars and journalists widely concluded that Fisher would have been rejected regardless of UT's consideration of race, as her application fell below the range of admitted students in the highly competitive holistic review pool. Out of 47,000 applicants that year, 12,000 applied via holistic review for only 1,700 available spots. The question then becomes, what was the actual ghost in the machine that ultimately doomed her case? But what was the ultimate ghost in the machine? The one secret that ultimately doomed Fisher's decade-long legal battle? The answer lies in a critical detail Fisher's legal team never adequately addressed, or perhaps chose to ignore. Her academic index, or AI, was simply too low to be competitive, regardless of race. The University of Texas utilized a grid system for holistic review applicants, combining their PAI and AI scores to determine admission. Fisher's academic metrics placed her below the threshold for automatic admission, and her overall application, even when stripped of any racial consideration, did not meet the competitive bar for those admitted through holistic review. In fact, university records showed numerous minority students with significantly higher PAI and AI scores than Fisher were also rejected, demonstrating that race was not a golden ticket. Her fundamental argument that a less qualified minority student took her spot was, according to court documents and university analysis, inaccurate. The irony then is profound. Fisher's prolonged legal challenge, framed around racial discrimination, ultimately revealed that her own qualifications within the highly competitive UT applicant pool were the true determinant of her rejection. This fact, obscured by the legal focus on the nuances of affirmative action policy, served as the silent but decisive factor in her case. Ultimately, the saga of Fisher v. University of Texas offers a profound irony. A decade-long legal battle, framed nationally as a fight against racial injustice in university admissions, was fundamentally predicated on a misapprehension of the applicant's own competitiveness. The documented facts reveal that Abigail Fisher's academic and personal achievement metrics positioned her outside the competitive range for admission, irrespective of the affirmative action policies she challenged. Her case, therefore, inadvertently illuminated how deeply ingrained narratives about fairness and merit can sometimes overshadow the objective realities of an admissions process, setting a critical, albeit often misunderstood, legal precedent that would influence the eventual overturning of affirmative action. This case forces us to consider: how often do deeply held convictions about perceived injustice blind us to the underlying facts of a situation? Share your thoughts below. If you found this breakdown insightful, subscribe for more deep dives into the legal cases that shape our society. And if you're curious about how Fisher directly influenced the Supreme Court's 2023 decision on affirmative action, my video breaking down Students for Fair Admissions v. Harvard is exactly the next thing you should watch. This video presents publicly documented information. It is for educational purposes, not legal advice.